Heather, and this is going to be an update in the Delphi case. We are talking about, of course, the case against Richard in Indiana versus Richard Allen for the unalivings of Libby and Abby, the young teenage girls who went for a walk one beautiful day in Delphi and they never returned home. So we're going to continue on our wild ride that is the Delphi case because there's been so many motions this week. I'm gonna do a couple different videos because I'm just gonna break them down a little bit differently. So for this week, for Delphi videos, this first video is going to be on Nick Mcleland and how he is claiming, the defense is making things up. They have no evidence and they're full of contemptuous conduct. And, we've heard it all. So we're going to, well, maybe we haven't heard it all, but I feel like and don't want to say that it can't get much worse, but who knows. All right, so 4-2, so what was that? That was Tuesday. The court issued this order. Judge Gull, Judge Francis Gull, sorry. So the court, having had defendant's motion to dismiss for destroying exculpatory evidence under advisement following a hearing conducted on March 18th, 2024, now denies the motion to dismiss as the defendant has failed to show that the evidence was exculpatory and that it was destroyed negligently, intentionally, or in bad faith. And okay, so on my channel, I did the transcript reading. Bob Mata of the Defense Diaries and some other content creators paid for the transcript of the March 18th hearing. We got to read through the entire hearing for the motion to dismiss and the because of the exculpatory evidence being destroyed, and it's very interesting, and it's really baffling that the mass media isn't covering it more because they really, really should. Instead, they just want to blame Richard Allen and not look at any kind of, evidence or things to back that up. All right, so moving on. The recordings of interviews between February 14th through the 20th, 2017 were lost due to human error or were spontaneously lost due to the equipment resetting. At the time the interview of Brad Holder was lost, he was not a key suspect in the case, and I don't think that that's true because he was looked at right away because he was a suspect. So, whatever, Judge Gull. You're not quite factual there. So the interview was memorialized in a written report provided to the defendant, Patrick Westfall. Okay, so the written report, which comes from a police officer who could be lying. It's a written report, a written police report, basically. So it is from the perspective of the police officer. It is not a signed witness statement, which also is not even as good as the interview, the actual recorded interview. All right, so moving on. Patrick Westfall, who is the actual person who took the pictures, not someone that Andrew Baldwin had requested him to do. So, this person went behind Andrew Baldwin's back and did that. So, Patrick Westfall. He was interviewed at his home by FBI agents. The interview was not recorded but was documented in a written report provided to the defendant. Again, still not sufficient. And in a day and age where everyone can have body cams, why aren't they having body cams, law enforcement? To take written statements for that reason. So you don't have to take written statements. You can record it, and then no one has to try to interpret it, but maybe a jury and not just Officer Joe's word for it. As neither Holder nor Westfall were suspects at the time the interviews were conducted, that is also not true. The defendant has failed to show that the lost interview of Holder was material and that the lack of a recorded interview of Westfall was material. As defendant must establish materiality to claim a denial of due process, and Allen has failed to do so, his due process rights have not been violated, so says Judge Francis Gull on the 2nd of April. So here is another order that came out this week from Judge Gull, and she says the state of Indiana's motion for leave of court to subpoena third-party records, mental health records, filed March 14th, 2024, granted without hearing. Big effing surprise. Here, Judge Gull is granting a motion for the state without hearing and doing so, relatively quickly. Whereas, all the other motions that Allen's attorneys have been filing don't get an answer or don't get a response at all, or they just get delayed. What was I going to say about this? I lost my train of thought now. Sorry. I was going to say something about... I don't remember. I lost my train of thought. So anyways, okay, so state of Indiana's motion, sorry, to leave of court to subpoena third-party records, mental health records, filed the 14th, granted without hearing. Oh, that's what I was going to say, was that this was also without hearing. She did have a hearing. Sorry, she did have a hearing on this, but she already had her mind made up before she even went in there, that's for sure. But all the other motions that, Baldwin and Rosie have been putting forth keep getting denied without hearing. And then these people get, the prosecution puts in a motion for his mental health records and gets them, immediately. Pretty much. All right. So the state of Indiana's motion for leave of court to subpoena third-party records, medical records, filed March 14th, granted without hearing. And that's her order. So getting those orders out of the way, now I'm going to start reading the filings that came out by the state this week. So Nick Mcleland, he put out a state memorandum in support of contemptuous conduct, which is the they had two hearings on the 18th, and there was a second hearing that was the morning hearing, I believe, was the contemptuous conduct hearing, and we don't have the transcript for that one. We only have the transcripts, unfortunately, for the motion to dismiss, but that one's actually more important that we have that one than this contemptuous conduct, because this was a bogus thing anyways, and they had it prepped and ready to go the day after Baldwin and Rosie were reinstated by the Supreme Court. And then Nick Mcleland puts out a bombshell filing for contemptuous conduct, which he shouldn't have even done, because it should be filed differently, and Judge Gull has no authority over punishing them like that with contemptuous conduct. But anyways, let's move on. We've been through all those motions already. So this came out the 1st of April. State's memorandum in support of contemptuous conduct. That's better. Okay, so introduction. Now comes the state of Indiana by prosecuting attorney Nicholas C. Mcleland and files its findings of fact and conclusions of law for the hearing on the information of contemptuous conduct filed by the state. A hearing was held on the contemptuous information on March 18th, 2024. Evidence was heard and concluded. The court accepted the exhibits into evidence and took its decision under advisement pending memorandums filed by each side. The state now files this memorandum in support of the information for contemptuous conduct. To contemptuous conduct. The exhibits that the state put into evidence support the contemptuous conduct on the part of Brad Rosie and Andrew Baldwin outlined in the state's information for contemptuous conduct. The deception to the court began in November of 2022 when both Brad Rosie and Andrew Baldwin told the court that a gag order was not necessary because they had no intentions to talk to the media about this case. I don't know if that's exactly what they said, but they have every right to talk to the media when it comes to certain facts of the case, which they didn't even like breach. And as a lawyer, they have only, as a defense attorney, you can only talk about certain things, whereas the state has pretty much the whole power and everything behind them. They can talk about anything they want and feed it to the news however they want to, anonymously or straight to them. And they didn't violate any gag order because the gag order hadn't been put in place yet. So any comments that they did make, which weren't violating their oath as an attorney, somehow violates a gag order that wasn't even in place yet. A futuristic lawbreaker is what they are. All right, so within a week, both Brad Rosie and Andrew Baldwin published a press release to media outlets. Brad Rosie testified at the contempt proceedings that this was to curry favor with his client. It is clear that the press release was to curry favor with the public. Although it was not a violation of any gag order, it was a preview into future contempt shown to the court by showing blatant dishonesty. Get over yourself, Nick Mcleland. Like, that's the worst thing you've done your whole career. Come on. The next act of indiscretion was an email from Andrew Baldwin to Brandon Woodhouse. This email was a violation of the gag order. No, it wasn't, buddy. Have you never done anything wrong? It was an accidental, misdirected email. The email released information from Discovery to a member of the public. The member of the public then further disseminated information protected by the gag order by putting it on the internet for the world to consume. Did that happen? When did that happen? While the content in that email may not be egregious to the court, the fact that Andrew Baldwin and Brad Rosie hid their error from the court until it was found by the state is egregious, showing yet another example of the defense deceiving this court. That is such baloney, because they had no requirement to tell the court or the to tell Nick Mcleland either. It's like he's just mad that he wasn't told about it or something, even though he had no right to know. All right, so finally and it was a list. It was a list of evidence, like a list of the different things that they were going to be using as their, part of their strategy. It was just a list of different pieces, like exhibits that they were going to use, basically. So it didn't give them any of the exhibits to click on or, open. And how is that, even if the list wasn't disseminated, by more than one person. Disseminated really means to, give out on like a more of a widespread thing, not just, to one person, but um whatever. They're just being so petty. I can't understand the state or Gull in this case at all. So finally, the defense intentionally and knowingly leaked information to the public in the form of crime scene photos and other discovery protected by the gag order that wasn't even in place. Well, at that time, with the leaked photos, I guess the gag order was in place, but originally it wasn't. And when Rosie made his statement to the press, there was no gag order, and he didn't do anything outside of defending his client. All right, so where was I? The gag order. The state admitted screenshots of text messages between Mark Cohen and Robert Fortson, neither of which are involved in this case in any way, nor are they employees or team members of anyone involved in this case. While these screenshots are voluminous, they paint a clear picture. Robert Fortson speaks about information that is only privy to the defense. Robert Fortson talks about it within days of the defense receiving discovery from the state. Robert Fortson has copies of the crime scene photos. He knows, see, unfortunately, because we didn't get the transcript, we don't know what exactly was testified to. So we don't know what exactly is a lie and what is truth within this whole narrative of Nick's, because we know he doesn't always tell the truth. All right, so while these screenshots are voluminous, they paint a clear picture. Robert Fortson speaks about the information that was only privy to the defense. Fortson talks about it within days of the defense receiving discovery from the state. Robert Fortson has copies of the crime scene photos. He knows when defense is working on certain aspects of the case, and he knows about the oral interview with Professor Turco 3 days after the recorded statement is turned over to the defense. What if the state is leaking this information to these individuals and blaming it on the defense? Ever wonder about that? I mean, I know Mitch Westerman admitted to stealing or taking photos of the girls, Mitch Westerman here, but he didn't say why. Well, maybe the state was trying to get to him. Maybe the state was blackmailing him or, coercing him to somehow, betray his buddy. I don't know. I'm just speculating. We don't have a reason why Mitch Westerman did it. All right, so the defense states that Mitch Westerman broke into their office and stole the pictures and then released them to Robert Fortson. It is clear from the messages between Robert Cohen and Robert Fortson that Robert Fortson received the crime scene photos and other discovery from Mitch Westerman. Okay, but my theory still stands that it is possible, and I'm not saying that it has happened, but it is possible that the state got to Mitch and made Mitch do this and said, well, if you do it, we'll go easy on you if you do get caught. Don't worry about it. I don't know. I would not put it past the state at this point. So it is also clear that Mitch Westerman was feeding Robert Fortson several other pieces of discovery all the way up until October 2nd, 2023. The leak was recurring. No, it wasn't. And where's your proof? It is also clear from the text messages between Mark Cohen and Robert Fortson that the strategy to leaking the information is to gauge the public opinion of the leaked information. Okay, but never mind. I'll just keep reading. It was an effort by the defense to put the information out to the public to gauge their response of the defense's theory of the case. This would allow the defense to change that strategy if the public response wasn't one that they thought was beneficial. So the screenshots from the iCloud account of Mitch Westerman. Screenshots are of text messages between Mitch Westerman and someone named, quote, Andy. Again, the messages are voluminous, but if the court will read through them, the court will clearly see that Andy is Andrew Baldwin. In the text, Andy talks about writing the Franks memo and how it is a huge endeavor on his part. In other messages, Andy encourages Mitch Westerman to reach out to the media and push their narrative. Andy further states that he has already been in touch with Dateline and spoke to them. I don't know. I don't know. I don't know. Is that true? Is Nick making this shit up? I don't know. All of this is a violation of the gag order by Andrew Baldwin and the defense. I have my doubts that this is actually, factually, what was said and what happened. All right, so when the state was notified of the leaked crime scene photos in early October 2023, the defense was on a phone conference with the court and gave the court the explanation that Mitch Westerman broke in and stole the photos. When interviewed by the Indiana State Police, Andrew Baldwin stated that he gave the Franks memo to Mitch Westerman to review. Then at the hearing on March 18th, the defense implied that Mitch Westerman is now a consultant of the defense and any communication between Mitch Westerman and Andrew Baldwin should be considered work product. Actually, they're not lying about that. That has been true from the beginning, and that's the whole reason as to why he was consulting with Mitch Westerman to get his idea. Mitch Westerman has a law degree. He's not a practicing attorney, but he has a law degree, and he understands the law, and he has Baldwin has brought Westerman in on other cases to consult with from time to time, and I believe he even worked in that out of that office as a consultant for a period of time. So that's not just some made up BS. And also, it's okay to talk about if you're a lawyer and you are trying to strategize your case and you want to talk about it with people that you work with or have a trusted relationship with. Granted, this person shouldn't have trusted him, but I mean, if you have that level of trust between you and someone, why are you going to question it? It almost does make me think maybe the state intervened. I don't know. Why did the defense make the court and the state aware on the October 10th, 2023 phone call that Mitch Westerman was a consultant and that he had access to discovery in the state's belief that the defense was trying to conceal or diminish Mitch Westerman's role in the leak? A reasonable person can deduce that the defense was trying to hide the fact that the defense was intentionally leaking information. Once the state was notified of the leak, an investigation began where the state began to gather evidence. As the state got closer to the source of the leak, the defense changed their story from Mitch Westerman being a criminal who broke into the office and stole discovery to Mitch Westerman being a consultant assisting on the DELPHI case, whose communication with defense is protected work product. I mean, both can be true. He could have been a consultant working on the DELPHI case and still took the pictures. Both can be true. I don't know why Nick's got his panties in a bunch. So the defense intentionally violated the court's orders and leaked discovery information in an effort to push their narrative out to the public to gauge public response. This was a strategic move by the defense in violation of the court's orders. Like Nick Mcleland hasn't been doing the same. Come on. The crime scene pictures specifically continue to cause havoc across the internet. Where? When? How? Who has seen these photos? It is not continually wreaking havoc. It is not even a leak. It's a drip. It barely went anywhere. It stopped. it has been stopped. So I don't know what this guy is even talking about, that it's still re-victimizing the families. No, it isn't. You doing this hearing, that's re-victimizing the families, and by delaying justice for their children. Delaying justice for Richard Allen is delaying justice for Abby and Libby, because the sooner we go to trial and find out that there was an Odinist tie and Brad Holder and some other people should be in prison instead of Richard Allen, then, there might be some problems. I don't know. All right, so the crime scene pictures specifically continue to cause havoc across the internet. As recently as March 28th, 2024, a YouTuber posted the leaked crime scene pictures on his channel to the public and ultimately to the world. That YouTube video made it back to the family, re-traumatizing them. Well, who is the asshole sending it to the family? Because that's the problem. I mean, I I I don't get why it's such a big deal. I People are so sensitive with like crime scene photos nowadays, and I don't understand it, because if you watch the Dateline episode of the Menendez brothers, you can see full on pictures of Kitty and Jose's body parts all over. And we didn't care about that. We would post those things all over. And now all of a sudden, like, to me, I don't like it for the sensationalism or whatever. This is just my personal opinion. Don't come at me if you disagree. You can tell me your opinion, that's great, but don't tell me why my opinion's wrong, because it's my opinion. I yeah, I don't think crime scene photos are that egregious to look at. I mean, a lot of people are like, I don't want to see that. I don't want to see that. But to me, I'm doing all of this for true crime to learn. And to learn, you might learn something from the photographs. So to me, it's not as big of a deal that they're out there. And if somebody wants to see them, they can. But it's the jerks that are like, hey, family member of this person who's on the internet, who's already a famous person because they're on the internet for, some horrific crime or something. You see that person, and I don't know where I'm going with this. I feel like it's educational and we can learn things from the photographs. And it's not everybody's cup of tea, and I get that. I just don't think it's appalling. And I think everybody who acts like it is, get over yourself, because we were posting them all over the place in the past. And media, I mean, like media and the public at large. So I'm not even going to go into the whole argument of it. I just think that it's stupid. All right. I don't know how I got onto all that. Okay, so, the YouTuber posted the leaked crime scene and sent it to the family. It has become known that the YouTuber forwarded the pictures onto other YouTubers, and they continue to be posted on the World Wide Web. You can't stop. I mean, I don't know. If somebody wants to find a way to get the photos, they're going to find a way. Despite the state and investigators spending countless hours trying to track down, I mean, some of these are public documents anyways, I mean, not in a case that hasn't been tried yet necessarily, but if you do a FOIA request, you can sometimes get these images. So it's not like it's the end of the world that they're out there, in my opinion. Don't come at me if you don't believe, if you don't see it the same. Like I said, it's my opinion. All right, so despite the state and investigators spending countless hours trying to track down all the various outlets the pictures and discovery were leaked to, the damage done by the leaked crime scene photos seems to be ongoing. I still want proof of all these things that Nick is saying because I don't believe him. But number three, governing law. Contempt is an inherent power of the courts. The contempt power is not bestowed on the courts by statute. Among the inherent powers of a court is that of maintaining its dignity, securing obedience to its process and rules, rebuking interference with the conduct of business, and punishing unseemly behavior. So their behavior is bad and you should punish them, judge. But everything I've been doing, it's all good. Even all the little forms of misconduct I'm doing over here, don't look at that. Just look over here at these guys. So the statutory definition of contempt is just legislative recognition of the court's existing authority. The same inherent authority can support sanctions without contempt. Courts can exercise their inherent authority to enforce their orders and protect their dignity through sanctions that are not explicitly tied to a contempt finding. Courts have upheld this imposition of sanctions in a number of contexts not explicitly involving contempt. A commonality is that these circumstances arose within an ongoing judicial process and the sanctioned persons were engaged in that process. Contempt, collecting examples of court sanctions for party or attorney conduct without formal contempt finding. All right. So contempt is a unique proceeding. It is not civil or criminal. State versus Heltzel. Contempt, however, is not criminal offense. I don't know how to say that word. Those words. Let's look it up because I like to learn law. So let's look that up. I've never heard of that. Something generous meaning of its own kind. Let's see if I can. Hello, phone.
Sui generis.
Sui generis. Okay. Sui generis. Of its own kind. So it is a sui generis proceeding, neither civil nor criminal in nature, although both of these labels are used to describe certain categories of contempt. Criminal contempt is not always readily distinguishable from civil contempt, but a particular contempt proceeding is described as civil or criminal in nature based primarily on the purpose of the sanction. Civil contempt is the label applied to sanctions meant primarily for the benefit of the party who has been injured or damaged by the failure of another to conform to a court order issued for the private benefit of the aggrieved party. Criminal contempt is generally regarded as an act directed against the dignity and authority of the court. So that's what he's trying to say here. Well, I don't know. Because he's saying it's in and of its own thing. But so criminal contempt is, generally regarded as an act directed against the dignity and authority of the court, which obstructs the administration of justice and which tends to bring the court into disrepute and disrespect. Criminal contempt sanctions are considered punitive because their purpose is to vindicate the authority of the court and it benefits the state rather than the aggrieved party. Okay, contempt is either direct or indirect. This is his, okay, He should have explained this long before when they wanted a definition of whether it was going to be civil or criminal contempt. Contempt is either direct or indirect. In IC 3447-2 is the chapter addressing direct contempt, and 47/3 is the chapter addressing indirect contempt. Direct contempt is based on conduct that happens in or near the court itself. Under IC 3447-2 4A, there is no written charge or complaint that is required. The court simply states the offending conduct and later reduces it to writing. The court may immediately enter judgment and punish under IC 3447-2 4B through D. Indirect contempt occurs outside the presence of the court. The statutes identify 4 distinct bases for indirect contempt: disobeying process or a court order as outlined in that statute, resisting, hindering, or delaying a process or order as outlined in that statute, intimidating a witness as outlined in this statute, there's so many statutes, or false reporting about a case or proceeding as outlined in that statute. Because the conduct happens outside the presence of the court, someone has to inform the court of the conduct. Then notice is given to the accused with a chance to confront and answer the allegations. In our case, the court is considering indirect contempt where the defense was given notice and a chance to be heard on the information. In Indiana contempt, it is a completely unique proceeding. It comes from the court's inherent power to enforce its authority and protect itself from interference. The words civil and criminal are just descriptions of types of contempt based primarily on the purpose of the sanction. Civil contempt sanctions are meant to benefit the other party, and criminal contempt sanctions vindicate the authority of the court itself. The same contemptuous conduct can give rise to sanctions of both types. Prosecutors, like any party or any responsible person with reason to believe someone should be held in contempt, can file a verified information with the court providing the reasons. Okay, but a reasonable person. Prosecutors, like any party or any reasonable person with reason to believe someone should be held in contempt, can file a verified information. So they're saying anybody can file a verified information? I did not know that. Okay, so whether that's interesting. Can we get a verified information on Judge Gull's contemptuous conduct and bias in this case? Whether the alleged contempt must be addressed in a separate case by a different judge depends on the type of contempt alleged, the defendant's alleged conduct, not the purpose of the sanction. This all should have been laid out before they even went to this hearing. Am I wrong? Like, what? Thanks, Nick, for dropping the ball and not telling us until after the hearing that this is the kind of contempt you meant. The statute lays out this procedure. The statute says no special judge is required if the alleged conduct is disobeying a court order, which is the conduct alleged here. No special judge is required in indirect contempt growing out of willfully resisting, hindering, delaying, or disobeying any lawful process or order of court. The allegations here by the state are that Andrew Baldwin and Brad Rosie willfully disobeyed the lawful order of the court after they were served with it. To constitute indirect criminal contempt, the act must be done with the intent to show disrespect or defiance. That's Matter versus Hatfield. Intent is a factual issue to be decided by the court after hearing all the evidence. And you know Judge Gull is just going to say, well, of course their intent was contemptuous. Of course it was. Intent is a factual issue to be decided by the court. Good luck, guys. Good luck. Our Supreme Court has held that the respondent has the burden of establishing that her failure to obey the court was not willful. That's in Jones versus State. The determination of whether to find a party in contempt permits the trial courts to consider matters which may not, in fact, cannot be reflected in the written record. The trial court possesses unique knowledge of the parties before it and is in the best position to determine how to maintain its authority, justice, and dignity, and whether a party's disobedience of the order was done willfully. So the trial court possesses unique knowledge of the parties. If you say so, I think Judge Gull's unique knowledge of the party is that she knows she doesn't like Baldwin and Rosie. If the court finds a party in contempt, the court can sanction that party. The purpose of this sentence imposed, which the state refers to as a sanction, was to vindicate the authority of the trial court and not to punish for the commission of a criminal act, as defined by the Indiana legislature and codified in the criminal code. In this case, there is indirect contempt by the defense. The state has presented evidence from which the court can find that the defense intended to leak the information from discovery, which is a violation of the gag order and the protective order. The court has witnessed many of the violations that the state presented at the hearing on March 18th, that in conjunction with the exhibits that were submitted into evidence, meet the burden for contemptuous conduct on the part of the defense. The sanctions for said contempt are left for the court, but should ensure that this type of conduct does not occur again by the defense. So they want sanctions. They're not asking for, they didn't ask to have him kicked off again, which was good because, the Supreme Court might have had something to say about that. But, so anyways, Nick wants sanctions. Nick really wants sanctions on these guys. So that's what that seems to be here. But now this is the more interesting reading. The state's response to the defense's third motion for Frank's hearing. Now comes the state of Indiana by prosecuting attorney Nicholas C. Mcleland and files its response to the Richard Allen's third Frank's notice and request for Frank's hearing based upon newly discovered evidence and request for findings of fact and conclusion of law upon any ruling on this request referred to by the state as the defense's third motion for Frank's hearing. So there's a third motion for Frank's hearing because they were denied every time and all without hearing. I mean, she should be able to give them, an hour or two of her day to hear this, but no. The state has reviewed the defense's motion and believes that the defense has misstated the facts in the motion and would respectfully ask the court to deny the motion without a hearing. The defense's third motion for a Frank's hearing alleges that Tony Liggett failed to include information about geofencing data in the probable cause affidavit for the search warrant for the residence of Richard Allen. The defense claims that if this information was included, the court would not have found probable cause to issue the search warrant. The defense seems to claim that the missing information is exculpatory as to Richard Allen. However, the information from the geofencing data is mischaracterized and interpreted by the defense. even if included in the affidavit, that geofencing data would not negate, cancel, or eliminate the facts that supported probable cause for the search warrant regarding Richard Allen's residence. I don't think so. That geofencing says that there were multiple people in the same area of the time of when the state alleges the crimes happened. And Richard Allen's phone is not one of them, but four other individuals are. Or three. Sorry, I think it's three. At least three. And, yeah, I don't know why that information was never brought forth to the defense. So even if it included, sorry. Further, Sheriff Tony Liggett did not intentionally lie or omit material information about evidence in an effort to mislead the judge. In the search warrant affidavit, the state of Indiana filed charges against the defendant, Richard Allen, in the cause of action on October 28, 2022, for 2 counts of unaliving in violation of IC 34, whatever. The defendant has been in custody since his arrest. The court appointed the defendant representation on November 14, 2022. Since that time, several motions and responses have been filed by both the state and the defense. The defense filed its first motion for a Franks hearing on September 18, 2023, with a memorandum, attachments, and several exhibits. That motion was followed by the defendant's supplemental motion for Franks hearing filed on October 2nd. Excuse me, I keep getting hiccups. Sorry. And the defendant's additional Franks notice filed on October 3rd. So, wait, what? Oh, defendant's additional. So that's the memorandum, supplemental motion. And then an additional Franks notice on the 3rd. All motions were denied by the court without a hearing. The state has outlined the test used in Franks in its prior 2 responses. In order to have a Franks hearing, a defense attack on probable cause must be based on deliberate falsehood or acts of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. The claim should point out specifically the portion of the warrant affidavit that is claimed to be false and should be accompanied by affidavits or sworn statements or reliable statements of witnesses. The defense must show that there is inaccurate or omitted information and that probable cause is lacking if the omitted information is included. Franks versus Delaware. Herein, the Delaware and my brain totally went to Wayne's World, where they were trying out their new green screen in their studio, and they're like, "Hi, I'm in Delaware." Anyways, that shows how old I am. I love Wayne's World. Okay, so Franks versus Delaware. Herein, the defense claims omissions, if included, would negate probable cause for the search warrant of Richard Allen's residence. Specifically, the defense claims that Sheriff Tony Liggett concealed from Judge Diener that at least 3 phones were moving in and around the crime scene at the time when the unalivings would have been taking place, and that 2, the way that Lieutenant Jerry Holman memorialized his interview with Turco should cause alarm about what law enforcement choose to include or not include in their reports. Issue 1. That Sheriff Tony Liggett failed to make the judge aware that geofencing data showed at least 3 persons in and around the crime scene at the time of the unalivings. In our case, the defense is alleging that the crime was committed by several individuals involved in Odinism. The defense had filed several motions with this theory contained in the motions. The defense has filed several motions with this theory contained in the motions. Okay, why are we repeating our words so frequently? The defense the defense continues to promote this theory to the public with no evidence to support the theory. The defense have come to the point where they are making false statements in their motions in a continued effort to support the theory. So Nick Mcleland is flat out saying the defense are coming to the point where they are just making false statements in their motions. So wait, they've come to the point, like, I don't know. He says this is one of those occasions. The defense claims that the geofencing data shows 3 phones in the area of the crime scene when the unalivings occurred. The defense admittedly speculates that a map with 3 phone numbers is geofencing data that provides evidence of any of 3 scenarios. That people were walking around and were witnessing the unalivings taking place, and none of them identified Richard Allen. That 2 persons walking around saw nothing, and the unalivings did not happen on the 13th, which is, I think they happened after midnight, or, I think they were taken somewhere and then it was done later in the early morning hours of the next day. The persons walking around committed the unaliving, or 3, the persons walking around committed the unalivings. This, of course, promotes the defense's theory. Unfortunately, the defense do not understand how to read or interpret geofencing data, and once again have misinterpreted the information and have put misinformation in their motion. The defense was advised on March 4th, 2023, that state witnesses specializing in geofencing data would be ISP First Sergeant Christopher Cecil, FBI Agent Kevin Horan, and or ISP Sergeant Pete Glogoza. However, the defense filed their third motion for Frank's hearing based on newly discovered evidence that was available during the first discovery disclosure in October 2023 and in the second discovery disclosure after counsel was reinstated. The state witnesses for geofencing data interpretations would testify that AT&T collects data from devices to include geolocation data. AT&T geolocation data is offered from 3 sources: GPS, first known Wi-Fi triangulation location, second, and cell sites or timing advance, which occurs when a signal is sent from the cell tower to the device and then back to the tower. GPS, if received, can be very good with an estimated accuracy range of 3 to 15 meters. Wi-Fi or triangulation, thank you, estimated ranges. My God, words are hard now. I'm talking too much. Okay, so Wi-Fi or triangulation estimated ranges vary between 15 and 100 meters, and cell sites or timing advance can range up to several thousand meters. The cell sites or timing advance is inaccurate because the geofencing data estimates where the phone is based on how long it takes the signal to go from the tower to the cell phone and back again. This means that the device can be 3 to 15 meters from the pinpoint on the map up to several thousand meters, depending on how the information was collected from the device to the tower. When interpreting geolocation data, you can only consider that the device is somewhere in or near the estimated range area that AT&T provides. Thus, if an AT&T geolocation is in a geofence provided a Wi-Fi location with a center point on the Carroll County Courthouse, one could deduct that the location is a range of 15 to 100 meters from or around the center point. if that same scenario included a cell, site, or timing advance location. The actual location of the device could range up to 1,000 meters plus from where the pinpoint is located. That would include the entire town of Delphi and beyond. When a person is in a rural area, oftentimes GPS and Wi-Fi location services are not available. Therefore, AT&T must resort to cell site location data. This is not an accurate way to pinpoint the location of a device. Further, geofencing does not track movement, so the fact that a pinpoint moves within a certain area is not indicative of a phone moving within that area. The map that the defense refer to is actually geofence data from AT&T. The points on the map represent GPS longitude/latitude points provided as part of a geofence from AT&T. Each longitude/latitude point has a range of uncertainty. The point is not where the phone is, it is simply the center point of the measurement. So even though the longitude-latitude point is near the crime scene, the actual phone could be more than 500 meters away from the point in any direction. The points have no date, time associated. What's the point in them if it's 500 meters then? I mean, why are you offering it as evidence if that's even, 500 meters is a huge range. So why even offer geofencing? Like, why is geofencing relevant then? Why even bring it to trial as anything? If it's 5,000 meter up to 5,000 meters away, what good does that do for anybody? The points have no date, time associated with them on the map, and so the map does not indicate the date and time that the phone hit on that pinpoint, as this information has provided to the defense in spreadsheet form with discovery. They either choose to ignore the information or did not understand how to read the information. I have a feeling the defense will have their own geofencing experts that can say otherwise and speak to Nick's claims here. The defense's conclusion that 3 devices were found in or near the unaliving scene location at the time of the unalivings and what geofencing data means is an inaccurate evaluation or interpretation that is not supported by an analysis by someone with specialized training or knowledge in geofencing data. What makes Nick a geofencing data expert? The defense's conclusion fail to consider the estimated range of those devices in the AT&T records or how the pinpoint data was collected. Further, although phones may have a pinpoint on a map that is in the area of the crime scene, the actual phone could be several thousand meters away. That makes no sense. No geolocation expert assisting in the investigation concluded that cell phones were in or around the crime scene where the unalivings occurred. That's because the investigators didn't want to find them, or they already knew they were there. Maybe. The defense further fails to state that the owners of those phones were interviewed and cleared by investigators. This was certainly Sheriff Liggett's understanding when he signed the affidavit of probable cause. Okay, so were they, or was it just Sheriff Liggett's belief that they had already been interviewed? Like I believe his beliefs, but anyways. The defense should be required to provide reliable statement or sworn affidavits of persons properly qualified to interpret. Exactly. The state should be given the opportunity, not necessarily required, but they should be given the opportunity to have a um, a qualified expert look at the geofencing and interpret it. But he's saying to support their claims that the omitted information he's saying they need sworn affidavits or an expert saying that someone specifically omitted the information or whatever. That the omitted information, if included in the probable cause affidavit, would cause the judge to deny the search warrant request. So because I think it was Holman who wrote the affidavit. I'm sorry, who wrote the search? Yeah, the probable cause affidavit. Um, I totally lost my train of thought because Holman wrote the PCA, but he omitted the information that there were these 3 other cell phones in the geofencing data. But Nick is saying that, I don't know what Nick's saying. He's saying if included in the probable cause, I don't know. I feel like I'm falling apart here. My eyes itching really bad. And my brain's hurting. I don't know what to do. Alright, I just got 3 pages to get through. So let's get through this. Alright. So the defense should be required to provide reliable statements or sworn affidavits of persons properly qualified to interpret geofencing data to support their claim that the omitted information, if included in the probable cause affidavit, would cause the judge to deny the search warrant request for Richard Allen's residence. So they need some proof that if that information had been given to Judge Diener, he might not have granted the search warrant. There we go. I got my groove back. No, I didn't, because my eyes messed up again, and it's hard to read. Alright, so issue 2. Does Lieutenant Holman's summary of his Professor Turco's interview support the defense argument that law enforcement provided false information in the probable cause affidavit to obtain the search warrant for Richard Allen's residence? It is unclear as to the reason the defense chose to have at least half of the content of this Frank's motion address events that occurred nearly a year after the submission of the search warrant and supporting probable cause affidavit. It obviously fails to meet the burden due to the fact that the Turco interview could have no bearing on what the probable cause affidavit contains. However, if the defense is using this to support the assertion made in paragraph number 34 that law enforcement has attempted to conceal evidence or falsify information in other contexts in this case, it utterly fails for the reason that Lieutenant Holman did not conceal evidence or falsify information from Professor Jeffrey Turco. But we don't know that. For sure. I think he did. The defense alleges Lieutenant Jerry Holman interviewed Professor Jeffrey Turco and then lied about the contents of that interview and Professor Turco's statements. Lieutenant Holman interviewed Professor Turco in September 2023 at the request of the defense following his deposition. Lieutenant Holman's deposition included defense inquiry about investigative leads related to Odinism. The Lieutenant Holman advised that a Purdue professor had been consulted by other investigators, but that he did not participate directly in the inquiry. The defense pressed Lieutenant Holman to re-interview the professor as to his findings and conclusions. Lieutenant Holman did a follow-up interview of Professor Turco at the defense's request. Well, that's because you guys didn't hand over Turco's original stuff and you hid it from them. You absolutely did hide it. All right, so Professor Turco's initial report from 2017 clearly states in the introductory summary, it is not self-evident that these markings are runic inscriptions, nor is it immediately clear what they would mean if they were. However, the argument that these markings constitute an inscription inspired by Norse runes or modern recreations thereof is quite plausible. The following are conjectures based on the working assumption that these lines do in fact constitute a runic or runically inspired inscription. Clearly, Professor Turco was asked to assume the lined formations are runes. I don't know about that. So Lieutenant Holman did not attempt to deceive the reader or leave out key information from Professor Turco's report. However, Lieutenant Holman did another interview of Professor Turco to clarify his findings at the request of the defense. The defense outlines Lieutenant Holman's summary of that second interview in paragraph 18 of their motion. The defense then outlines that they believe Lieutenant Holman's summary should have stated in its report in paragraph 22 of their motion. The parties held a deposition of Professor Turco on March 21st, 2024. At the deposition, Professor Turco stated under oath that paragraph 18 of the defense's motion more accurately reflects his opinion by comparison to that which was stated in 22. Paragraph 18 is from Lieutenant Holman's report, while paragraph 22 is what the defense believes Professor Turco's report means and includes the defense's application of Turco's statements to facts about Brad Holder and Patrick Westphal that were not provided to Professor Turco for consideration. Professor Turco stated that he was provided with only a diagram of lines in certain patterns on a blank sheet of paper when he then replicated a color-coded for reference to this narrative report. Professor Turco went on to state that paragraph 22 does not accurately reflect his opinion at all. Professor Turco stated in his deposition that it is not clear that the sticks found on the girls represent Germanic runic script. The professor went on to debunk all the statements that the defense put on their motion, including that this was a ritualistic, sacrificial ending of life. He stated that nowhere in the recorded history of Odinism has a sacrificial ending of children occurred. But adults? Children, not okay, but adults are all right, occurred. And if by some chance that it would be the only one in recorded history and goes against the definition of ritual, since a ritual is something that is done over and over again. Okay. The defense outright lied to their motion, or in their motion is what he's saying, and misrepresented the true findings of Professor Turco. Lieutenant Holman reported the truth, and his statement that Turco's findings were inconclusive was correct. The defense's statement that Lieutenant Holman somehow was misleading in his report is entirely false. Finally, it is important to note that the interview of Professor Turco and Lieutenant Holman's narrative summary did not occur until nearly a year after the search warrant was executed Again, the defense does not even claim that the Turco findings are an omission from the search warrant affidavit, but rather than that it presumably is new evidence to support their claim that law enforcement as a whole is motivated to lie or misstate the truth as part of a conspiracy to protect Brad Holder or to withhold evidence exculpatory to Richard Allen. The threshold to be met for a Franks hearing would require the defense to show a substantial preliminary showing that a false statement was knowingly and intentionally given or given with reckless disregard for the truth, such that probable cause is lacking for the Richard Allen search warrant if the omissions are included or the inaccuracies are taken out. The Holman narrative of his Turco report are not relevant to the Richard Allen search warrant affidavit. The defense has routinely put theories and statements in their motions that are not supported by facts or any real evidence. This is yet another example of that. The fact that the defense has a theory of how the crime was committed does not warrant the state to put that into a search warrant. Conclusion, wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. Mcleland and files their response to the defendant's third motion for a Franks hearing and would ask the court to find that the defense has not met its burden to warrant a Franks hearing. The motion contains nothing more than their beliefs about what the geofencing data means without the necessary specialized knowledge to interpret the data, and summarily concludes that it must be exculpatory and therefore a material, intentional, or reckless omission in the probable cause affidavit for the search warrant. Sheriff Tony Liggett did not intentionally or recklessly omit evidence or lie about evidence in the probable cause affidavit to support the search warrant in an effort to mislead the judge. Well, how do you know? Bring Sheriff Liggett there and ask him questions. That's the only way you'll know if he lied or not. And even then you won't, because he's not going to admit the truth, but, whatever. You need to chip away at it in court or in a hearing, That there are no inaccuracies or omissions in the probable cause for the search warrant that are of a material nature, and the defense argument that law enforcement dishonestly is pervasive and relates back to the affidavit in question is not supported by sworn statements, affidavits, or reliable statements. So that was Nick Mcleland's response to the third Franks motion request, and we are going to, in the next video, I'm going to read the defense's response to the state's response. And that one's a little bit longer than theirs, so it's gonna be a ride going through all of these. So hopefully you guys hit that like button and the subscribe button so that you don't miss out on the next update that I have on here. I have 2 more planned out. This was just one of 3 that's coming. So hopefully, if you guys are interested in this, don't forget to subscribe and like, and YouTube will do all of its YouTube-y things to make sure that you don't miss one. All right. Thank you and take care. Thanks for watching. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.